Appeals of Tennessee is in session.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate in this oral argument via Zoom. We believe that it is the best way to continue to litigate and continue to determine appeals. So we appreciate you participating. I will remind counsel, all of you have been here before, so you understand how the appellate court works. We will follow the same protocols and procedures we always follow as if we were standing in court today. By that, I mean each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with the clerk previously, you'll receive that rebuttal time. I do not anticipate any technological problems. However, if anything occurs, everybody just remain calm. We'll work it out. Nobody will be prejudiced by anything that goes wrong here today. Miss Angie will take care of all that, or Kevin. So I feel very comfortable with that. Before we get started, though, I want to be sure and introduce your panel for this morning, rather. Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis as well, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before you call the case?
No, Your Honor.
All right, you may call the case.
Carolyn M. Stark et al. Versus William S. Mclean et al.
And we will hear from the appellant.
If it please the court, I'm Molly Williams. I'm from Dyersburg, and I represent the appellant Steve Mclean, his wife Donna, and Steve-Lynn Farms, which is a partnership made up of Steve Mclean and his brother Lynn Mclean. This is an appeal from a bench trial which was held at the Chancery Court in Dyer County. There are two issues that we raised in our brief. One is whether or not Steve Mclean should be held responsible for violating fiduciary duty as trustee of the Newbern Trust. And second, whether the award of attorney's fees was reasonable and supported by the law and the evidence. It may seem simple to say that if Steve Mclean was the trustee of a trust, he should have abided by the terms of that trust. But this case is very odd and different in terms of what was in the trust and the information that was provided to the parties before they formed the trust.
Ms. Williams, I'm sorry to interrupt you so early, but there's a couple of things that I wanted to ask you about, because there's a lot of balls in the air here, and I'm trying to figure it all out. But one thing that I thought perhaps you could help me with, and one of the issues that was raised by the appellees, their issue number 6 regarding CD number 671127. I was reading the judge's findings of fact, and he goes through a very detailed findings of fact. He says in May of 2000, Steve used POAs in his position as trustee to transfer 237 odd funds from Polly's account, Watt and Polly's joint account, into numerous CDs. These funds ended up in Steve Mclean's personal bank account or in the account of Steve-Lynn Farms. When this CD was closed, the funds were placed into Steve Mclean's personal account. He did not have the permission of either of his parents to transfer these funds. Instead, these funds were converted by Steve Mclean or Steve-Lynn Farms. By having the bank statements for this account mailed to his house, Steve concealed this post-Polly death CD from Watt. Further, the running of these funds to his multiple CDs for a number of years made it impossible, while exercising reasonable care for Watt, to keep track of these funds. And then in the conclusions of the law, the court reiterates these same things and says the activities were not concealed at all, could have been discovered with reasonable care. Since the transaction occurred, the statute of limitations to bring suit for the conversion of those funds has long since passed. How is that? How does the discovery rule not apply to these conversion of funds? It seems like I'm reading one thing in one place and one in another, and it just doesn't make sense to me. And I'm trying to see if you can help me clear that up.
Carolyn Stark, the plaintiff, actually was on the account of her mother. So she could have at any time checked to see what was going on in her mother's account.
But all of the records were mailed to Steve.
Actually, the ones I believe that Your Honor, is that the ones that dealt with Polly's account were mailed to the house so that Carolyn Stark did not look at them, but could have looked at them and was aware she was using that account.
You say the house, which house are we talking about here?
We're talking about Watt and Polly's house.
Okay, and at
This
this,
is by having the bank statements for this account mailed to his house, Steve concealed the post-Polly death CD transactions from Watt. That's what the judge found. And then go ahead, I'm sorry.
Those are the bank statements for the Newbern Trust account, which had formerly been Watt and Polly's personal account. Polly also had an account.
That's not what he's talking about here. He's talking about the funds from these CDs. This is a paragraph. He lists all these CD numbers and talks how they were transferred from one CD to another. And then he says, instead, Steve McLean did not have the permission of either of his parents to transfer those funds from their accounts into the accounts these funds were finally placed. Watt and Polly never knew these funds had been taken from their accounts. Instead, these funds were converted by Steve McLean for his or Steve Lynn Farms' own use. By having the bank statements for this account mailed to his house, Steve concealed this post-Polly death CD transactions from Watt. Further, the running of these funds through multiple CDs over a number of years made it impossible, even while exercising reasonable care for Watt to keep track of the flow of the funds. That's the CD he's talking about. That's 62117 CD. And then he ends up in his findings of fact and says the statute's run. And I don't understand it. And I thought maybe you could help me with that.
My understanding of his discussion about the statute running was on a particular CD that came from Miss Polly's account prior to her death, started out in her account and kept moving.
It's the same CD.
Well, there's a, if you understand.
I mean, I don't know this. I'm just here looking over what I'm looking over, and I'm reading what the judge wrote. And on one page he wrote one thing, and on the other page he says the statute, right. And I don't get it.
Your Honor, we did not appeal anything that had to do with the CDs.
No, but the other side did.
The other side did, and their question is over, I believe, the beginning of this, which was the original issue of a CD, and that happened.
The judge in this finally what he ruled ultimately was the plaintiffs did not and could not have discovered the activities surrounding this $132,186 in funds until after suit was filed. The court concludes Steve McLean wrongly converted $237,566.91 of Watt and Polly's funds for his own personal use, but claims to recover all but 132,000 of those funds are barred by the applicable statute of limitations.
As I said, Your Honor, my understanding was he was talking about the statute that ran on the original transfer of the original funds. There's actually a chart that was prepared by someone at First Citizens to show the flow of these CDs. It's very, very complicated.
And that chart is in the record, Ms. Williams?
Yes, sir, it is. Steve McLean testified that the family had always done that. They would buy CDs and shift them around. His father liked, if he had a little extra money, he'd go buy a CD. Not something I would do, but something that they did.
I'm done. Thank you.
Okay. As for the trust, Watt and Polly went to a seminar at the co-op and met a man named Hopkins. And in March of 2000, they went with him to form this trust. The trust that they got was called a life estate trust. And I take that as the beginning of the problem. It was a life estate trust that came with an operating guide and other kinds of materials, which we've gone over very, very thoroughly in our brief, that discussed how this trust worked. The problem was that isn't what the trust said. The trust was a prepared trust that does not say the same thing as the operating materials. For instance, the operating materials say that the trustee has no duties. He has no duty, and Mr. Hopkins testified that Steve McLean had no duties until there was a death. So he did not keep records. He did not even sign a check for the first 6 years that he was the trustee. He never wrote a check. He never kept records. He never handled anything. His parents kept up business as usual. They had a caretaker agreement. They did the rent the same way they'd been doing the rent. I think it's since 1988, where they did not collect the rent. Steveland Farms got the rent from the farms. That just kept going.
Were all of the father's assets supposed to be put into this trust?
The way you read the trust,
That's a simple question. Were all of the assets?
Yes, all of the father's assets and all of the mother's assets should have been put in the trust. They were not.
And that's including Mr. The father's bank stock.
Yes, sir. If you read the trust, it should have been put in there.
All right. Thank you.
But the problem was that neither Watt nor Polly actually had their personal funds transferred into the trust. So it would leave Steve Mclean having to order his parents to turn over funds. After the trust was formed, Watt gave away stock to all 4 of his children and then later to grandchildren. So they knew that he did not have the stock in the trust. He continued to treat it as if it was his own. Polly did the same thing. They continued
He also gave that stock to Steve's wife.
Yes.
2,400 some shares to Steve's wife.
Yes, he did. He gave the stock to Steve's wife after he had given to his children and apparently to his grandchildren based on Miss Stark's testimony. Then he gave stock to Steve's wife. But they basically did not change anything about the way they did their farming operation or really how they handled their finances. My time is up.
Yes, it is. Okay. You've still got your rebuttal time.
Yes, sir.
We will hear from the appellee.
Good morning. I'm Becky Bartell. I'm an attorney at Lanham Coronado Haight in Dyersburg, and we represent the original plaintiffs in this lawsuit, Carolyn Stark and Susan Lazenby. I want to start by addressing the question that Judge Golden asked about the conclusions of law from the trial court not being supported by the trial court's findings of fact. And that's particularly in regard to the conversion of CD 671127. I believe that we point in page 14 of our reply brief the way this CD was transferred from originally being Polly's to eventually being converted by Steve. The CDs were converted by Steve when he closed the CD early, incurred a penalty, and then took that money and opened a brand new CD in his own name. Steve testified that when he was asked at trial why he did that, he kept arguing with us that he did that after Polly died, which is simply just a lie. He closed it before Polly died and took the money and put it in a CD in his individual name. The plaintiffs had no way of knowing this happened. While Carolyn was on Mrs. Stark's bank account, she was not her power of attorney. She did not have access to these separate CD accounts. So the judge was correct in his findings that the behavior regarding the CDs was concealed, that the plaintiffs did not have any way of knowing that the CD had been converted. And for some reason, his conclusion of law is just not supported by his own facts. And so we would contend that those facts established that the CD was converted and that based upon the discovery rule, they discovered that after the lawsuit was filed and they had the ability to subpoena records from the bank to discover that conversion. Also, the CD chart that was prepared is attached to our brief as Exhibit E. Ms. Williams pointed out that the primary issues regarding this case are the trusts that were established by Watt and Polly Mclean. There were 6 trusts that were established. 4 were farm trusts that held individual pieces of property. And the primary trust was the Newbern Trust. And the Newbern Trust was the beneficiary of the farm trust, and its job was to collect income, to protect the assets, and for eventually for them to be able to avoid probate. Steve's whole position regarding absolving him of what was his fiduciary duties is simply absurd. the statement that, well, it was business as usual is simply not true. It was not business as usual. The creation, the hiring of an attorney, the hiring of Mr. Hopkins, the creation of trusts in which they signed and read, that shows that things were changing, that they had changed their plan from this was the plan prior to the trust to the creation of the trusts. There's no evidence, and the trial court found that the trusts were not ambiguous, and therefore the only thing that matters in this are the terms contained in the four corners of the trust.
Let me ask you a question. I have a question about your issue 4 and 5 because they seem to conflict with each other. One is whether or not the trial court erred in failing to find that a confidential relationship existed between Donna and Watt, and that this is in relationship to the transfer of the stock. And then number 5 was whether the trial court erred to find that Steve breached his fiduciary duty by failing to convey the first citizen to conveying this stock to the trust. In other words, as I understand it, and that's why I asked your opposing counsel, as I read the language of the trust, all of his assets should have been transferred to the trust. That would have included all of the bank stock. I understand some of it was transferred to these beneficiaries, but we're talking about this stock that was transferred to Steve's wife, and we've got a confidential relationship issue, and then we've also got the question of whether it should have been conveyed. It appears to me that from the plain reading of the trust itself, that the stock should have been conveyed to the trust. That conflicts with this confidential? In other words, it should have never been available to have a confidential relationship issue, but you can't have both here, and I'm not sure how to address that.
Yes, sir, you're correct. So we have these two issues that we've raised, and essentially they're alternative theories. And that might have been my mistake in putting the confidential relationship issue before the breach of fiduciary duty issue, because you're right. The first thing is Steve breached his fiduciary duty by failing to put the stock in the trust and allowing the transfer to happen. The second thing is that even if because it clearly wasn't in the trust, because nothing was ever put in the trust because Steve stole it all before it could be put in the trust. So even if it weren't in the trust, which it wasn't, this transfer is not appropriate. It is illegal due to the undue influence. And so that analysis starts with establishing that there's a confidential relationship between Donna and Watt. And we feel that we established that there was a confidential relationship between Watt and Donna. When you look at the court, and one thing I want to point the court to is the recent
trial
case.
court. Did the trial court find a confidential relationship between the daughter-in-law and Mr. Mclean?
No, the trial court did not, but it's our position that the trial court used the
Hold on just a second. And why did the trial court not?
Okay, the trial court, in our position, the trial court used the wrong standard regarding confidential relationship. One of
the burden of shifting
standard.
Yes, the burden, once there's an establishment of a confidential relationship, then the burden shifts to the person who received the gift to establish that there was not undue influence. And the trial court found that there were certain things, but I think the trial court got hung up factually on capacity issues, which really aren't an issue in a confidential relationship. A confidential relationship it's more than two family members and it's less than a fiduciary. And it's somewhere in between there based upon the case law that's available. And so our position and the facts we put on at trial and the facts that the judge found established that Donna was taking care of Watt. She saw him every day, that she was handling his medication, that she was handling his bookkeeping. She was paid a monthly fee to handle his bookkeeping. And so those facts that we presented established that there was a confidential relationship between Watt and Donna. And so at that point,
Standard did the trial court use then?
well, the trial court was not very clear in what standard it was using. The trial court said, well, Watt was in good health, and so it was not a confidential relationship. The judge did put in an alternative and said, well, even if there was a confidential relationship, there was an undue influence because this was something Watt wanted to do. And there is no proof to establish that was something Watt wanted to do. First, it was the burden of Donna to establish that it was a fair transfer. And the court recently reviewed this in the LSV Dugan case that came out of the Eastern Section in September. And this is a case that we haven't cited in our brief because it's too recent, but the court.
If you want to rely on the case, you need to file supplemental authority tomorrow, but be sure and serve opposing counsel as well.
Yes, sir. But what we're talking about here in an undue influence is you have, under an undue influence, the presumption shifts to the person who receives the gift, and it's their job to prove that the gift was fair. There's no evidence to show that Watt received independent legal advice, that anything about this transaction was fair. Donna knew that what Watt's assets were and that this was the last of his assets. She received all the bank statements. She managed the accounts. She knew what receiving this stock would do. And so we feel that all of the proof that we put on at trial established that there was a confidential relationship and that this transfer was due to undue influence. And so
let me ask you, Ms. Bartel, how would receiving bank statements make Donna aware that there'd been a transfer of bank stock? The bank stocks wouldn't show on a bank statement. In
Correct.
addition, one further question I want you to answer. Why do you say it was Steve's responsibility to effectuate the transfer of the bank stock into the trust? Why would that have been his responsibility? And then how would you go about effectuating the transfer? What would have to be done in relationship with the bank itself for a transfer of ownership of bank stock?
Okay. Well, first, Donna having the bank statements at her home, she knew what Watt's wealth was. She knew how much money he had on his account and knew how much money he needed for his care every day. And so she knew what his assets were. And that's the point of having the statements delivered to her home.
They don't include bank stocks.
No, it doesn't include bank stock, but she would have known. She may not say she didn't know what the stock was, but she did know that this is how much money he had in his bank account. But in regards to Steve was directed to put all of the assets in the trust, money, stock, and everything, which would mean his authority as trustee would be to go to the bank and convey the stock certificates, which were in his possession, that he testified to, that the stock certificates were in his possession. But to go to the bank and simply convey the stock.
Hold on a second. Let's back up just a minute. So if Steve didn't own the stock, how could he transfer the stock into the trust?
It was Steve's job as trustee to transfer the property into the stock, or transfer the property into the trust.
I understand that. I understand what you're saying. I'm not sure. I'm just like Judge Armstrong. I'm trying to figure out, if I don't own something and I don't have the right to transfer something, where does he get the right to transfer stock that is in someone else's name?
There was a specific memorandum that went down with the creation of the trust documents that directed Steve as trustee to convey their property, whatever their assets were, into the trust account or into the grant And so grant
him the authority to do that in that document?
Yes.
Is that document in the record?
Yes, sir.
Didn't the court find that the court made that finding when he was talking about these CDs? He says after May of 2000, Steve used these powers of attorneys and his position as a trustee of the trust to transfer those funds from Polly's personal account and Watt and Polly's joint accounts into those certificates of deposit. So he had power of attorney in addition to being trustee, wasn't it?
Yes, he was their power of attorney, and he was the trustee of the Newbern Trust and the 4 supporting trusts, and then the Polly Trust when it was created after her death in 2007. So he was their fiduciary in multiple different ways. He also served as the executor of both of their estates.
So let me ask you this. Assuming he had the power of attorney to transfer these shares, and he was the trustee and had the duty to transfer these shares, then we never even get to this confidential relationship issue, do we?
Right. We agree with that. But we pled this, and that's something that we've done several times, is pleading alternative theories in this case, because the wrongdoing by Steve was so egregious that there are multiple different ways he has breached his duties. He breached his duties as trustee. He breached his duties as fiduciary. He breached his obligations to his family. And so
let me ask you one other follow-up question with regard to that issue about the failure of Steve to convey these stock shares to the trust. The court did the court ever address that, or was that argued in the trial court?
we raised the issue to the trial court, but it was not something, it was again, one of the issues. The trial court had, the conclusions from the trial court do not address all of the issues. Fraud did not get addressed in the original order. We've asked for sanctions and additional relief regarding.
But you did raise it in the trial court.
Yes, sir.
And so the court decided to deal with it on the confidential relationship side of it rather than on the transfer side of it. Is that?
Yes, sir.
Okay.
Yes,
All
sir.
right. I just want to know if it was raised.
Well, let me make sure I understand what you just argued. Are you saying there were issues that were raised below, tried below, and the trial court did not decide?
The trial court in its final order denied all other issues. So there's not an issue where this is not a final appealable order.
Oh,
But
okay.
where the trial court put down specific findings or specific conclusions from the findings that he had, there's not that. Before my time runs out, I do want to point the court, one of the primary issues is the issue of attorney fees. And we pled that we're entitled to 100% of our attorney fees under the Tennessee Uniform Trust Act, specifically 3515-1004. It's our position that statute allows us to recover 100% of the attorney fees that our plaintiffs have paid in this lawsuit. And specifically, we would just raise to the court that it is allowing a plaintiff in this kind of case recover 100% of their fees makes these type of cases economically feasible. If they have to pay their own fees, they can't recover against the person who has lied and stole and destroyed records, then they are not allowed to, they wouldn't be allowed to pursue their case, and they wouldn't be allowed to get full justice, which is what they are asking for today.
I have one final question I need to ask you. I know your time's up, but I want to ask you this issue about the spoliation. You just mentioned this about destroying evidence and the spoliation issue. I know you raised that, and apparently at one point, Mr. Steve Mclean was ordered to produce tax returns and whatnot. And I'm not sure what the spoliation issue applies to, but there was an order that was subsequently entered in February of 2019, where the court essentially limited the requirement of his production of returns to 2011, 12, and 13. Does that affect the spoliation issue?
Yes, sir. We asked for sanctions and damages, allowing us to recover our fees for that. But the reason why this is such a big issue and the spoliation is such a big issue is because the Trust Act allows us to recover either the stolen property or the profits made from the stolen property. And without these records, without the tax returns, we can't determine what the profits were made. We know Steve has significant wealth now, but we weren't able to trace the funds, which is a remedy available to us under the Trust Act. So that's why this issue has been so important to us, and why we feel that we're entitled to specific relief, including 10% on prejudgment interest, including additional attorney fees for what they have incurred. That's why that spoliation issue is so significant in this case.
And I'm just trying to understand, what exactly are you saying the spoliation issue is applicable to? What records?
Specifically his tax returns, his personal tax returns. He testified in 2014, his wife testified that they had 2010, 2011, 2012, and 2013 taxes. And we were not able to get anything until 2 weeks before trial, when Steve was able to recover some of his tax returns from the Farm Bureau. And then at trial, he testified that his tax preparer could get the rest of the tax returns that he said he would produce, but because he just didn't get them. And so it is this continuance continual hindrance against the plaintiffs in being able to collect the information they need to recreate what has happened in this case.
Okay, thank you.
Let me ask you, after Matt and Polly created these trusts, did they ever actually transfer farm property into the trust? Was there ever a deed transferring ownership from them jointly to the trusts that were created?
Yes, sir. In March of 2000, they conveyed the individual farms to individual trusts. And that is what the Atkins, Edgewood, Collinsworth, and Pope trusts contain. And so there are deeds, and they are in the record, which shows their conveyance of the real property to the farm trusts. And then the Newbern Trust was created, and the farm trusts were to pay their income into the Newbern Trust every year. But that is part of the record. Yes, sir.
So we have evidence of them transferring the real property in the trust, but personal property like bank stocks, is there any evidence that they did that transfer? Because that would be their obligation, not Steve's actually. Is there any evidence that they did a transfer?
No, sir.
Okay.
All right, Ms. Williams, we will hear from you in rebuttal, please.
To follow up on the transfer of the property, the proof was that Polly kept numerous items of personal property, investment accounts, bank accounts. She didn't transfer anything to the account. Watt did not transfer anything. In fact, they didn't even open a bank account for the trust. They just called their personal bank account the Newbern Trust account. So they didn't make any attempt, except I believe there was a trust called the pickup truck, a Ford truck trust. At one point, they put a pickup truck in a trust. On the spoliation issue,
Well, hold on just a second, please. What is this memorandum of understanding that Ms. Bartell mentioned? When the trust was created, apparently some duty responded or was found in the trustee, I suppose, Mr. McLean, to transfer things. And I'm having difficulty, as Judge Armstrong is, figuring out what that obligation is here.
I'm not really sure which part Ms. Bartell is referring to. I think the trust itself said that he should transfer things, but as far as how he had the ability to transfer, and I will point out, by the way, that First Citizen stock, I believe, has not been paper stock. They do not use paper stock for a long time. And you can go through the process of how it was transferred within the record, talking about how Watt transferred it. But anyway,
Did your client have a power of attorney from his parents?
yes, he did.
Okay, thank you.
And what was that?
But as far as the
Just a second, was the power of attorney in effect at that point in time? Or did it depend upon the competency of the grantors?
I believe that Steve's power of attorney became effective when his mother died. He had Watt's power of attorney, but I would have assumed it be dependent upon the competency of the grantor as far as whether or not to use it. The discussion about
record, Ms. Williams?
Let me ask you about that, because the court made a finding that Steve used these powers of attorney and his position as trustee of the trust to transfer this money into the CDs. Now, where did the court get that from if Steve couldn't use these powers of attorney?
I believe he could use what I'm understanding would be that there was a power of attorney on file or available at First Citizens, so that they knew about that he had the power of attorney. As far as using his position as trustee, I don't believe that he ever said he was using his position as trustee to do anything. Though I believe that there is some form in the record that was something that told the First Citizens that he was the trustee of a trust.
So he just used the power of attorney to do these things.
I believe there was testimony that basically Steve or Watt or Polly would be in somebody'd call the bank, somebody'd go in the bank, and they just let him do things.
Is the power of attorney in the record, Ms. Williams?
Yes, sir. I believe that it is. I do want to mention on the spoliation argument, At some points, they've argued that the spoliation was destroying the farm records. The farm records were easily recreated by their farm expert using just basic knowledge that you can obtain from the internet. As far as the spoliation on the tax returns, the testimony was that Steve and Donna didn't keep records for very long, but they should have had those records. I believe in his testimony, it may have come out that Steve didn't understand the term cloud, that the tax returns were actually available in the cloud. He didn't know what his Farm Bureau was talking about when they said that. I do want to mention on the attorney's fees that there were many, many issues in this case that have absolutely nothing to do with the trust or my client. Mainly the issues that dealt with the Mclean Investment Trust. My client was not the trustee of that. The trustee of that, Mr. Hopkins, eventually filed bankruptcy. But that issue is not an issue that had to do with my client. Also, there are issues in which you are not entitled to attorney's fees, particularly the question of conversion. They were not entitled to attorney's fees for that. They were not entitled to attorney's fees for anything on which they did not recover. So what we have is a massive amount of paperwork to support attorney's fees. And the judge says, well, I think 70% of that relates to the trust. But he didn't actually show how he came up with that. He said he went through everything and looked, and I'm going to give him 70%. The other thing is I still think Rule 5404 applies here, and they should not have received all of the expenses that they received.
Okay, thank you. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you again for participating via Zoom. Ms. Angie, anything we need to take up before we recess to the call to the next case?
No, Your Honor.
All right, you may recess court.
This honorable court is in recess until 11 a.m.
Thank you.